Again, this is our Gilfix and Avenidas Law at Home webinar. Again, we want to thank Avenidas for having us here today. And as we get started, I want you to think about what got you to sign up for this webinar. What is keeping you up at night? What is stressing you out? Are you worried about your finances? Are you worried about your health? Are you worried about your future? Are you worried about your family's future? Or do you just feel overwhelmed and you just don't know where to start? Again, needless to say, we live in unprecedented times. The stock market has been up and down and down and up. We're living in an incredible pandemic we haven't faced in over 100 years. Now we have wildfires burning throughout the state, throughout the Western United States. It's chaos. There's so much we can't control, but there is a lot that we can control. And we are here to help you to understand some of the steps you can take to take some charge of your affairs. So as we dive in, we want to start with a tale of planning ahead.
Yeah, what we're going to do now is take a look at a situation that we see repeating itself in so many different contexts. It's sort of a what's the result of planning or not planning? So let's take a look at that screen. If we have it, it's a tale of planning ahead. So as it comes up, here we go. So we have two individuals, and this is just really very simple in a way, yet very, very, very significant. Okay, so we have Larry and we have Wyatt. Larry has a business. The estate's worth a couple million, maybe a little bit more. Very supportive family, wonderful family. He has an accident. As a result, he's seriously ill, incapacitated, can't do anything for about 3 months. During that time, everything goes to hell. The business falls apart, bills aren't paid, deposits aren't made. By the time he recovers and comes back to his business, it's a mess. And recovery financially did him enormous damage. Now, Wyatt, similar profile, also has a small business, same size estate, also a supportive family. Everything is good. He has the accident. Same thing, incapacitated, out of it for about 3 months. But when he comes back, everything is fine. Everything was, all the bills were paid. The business was managed. Everything was excellent. And so the question is, what's the mystery? What's the difference? What did Wyatt do that Larry didn't do? And we'll revisit this a little bit later as we resolve these questions about crisis planning and how do you prepare for the realities of life?
Yeah, and really that's the subject of our talk here today, legal planning for a crisis. And we want to start with the 3 critical documents that you and your family absolutely need, and they need to be up to date, even if you already have them. The talk that you have to have with your loved ones and your family and your decision makers, or maybe it's your friends, or maybe it's your relatives, depending on the situation. The decisions that you have to make when you set these documents up. What are the key decisions you have to make? And by the way, you have to revisit these decisions whenever your situation changes. So what are these key decisions you have to be thinking about? And how do you put this all into place? What are the steps you have to take? So that's going to be the focus of our talk today, but we're also going to spend just a little bit of time about the upcoming elections and how that might affect some tax planning steps that you might have to take. So on that note, we will jump in to how they are also used in emergencies. Actually, so also just in the context of what we're facing now. Fires, pandemic. These are, again, scary times. When are these documents put into place and how do you use it? If you do face an emergency, you and your family face a crisis, how do these documents do their job for you? So we're going to talk about that as well. So I think for those of you who don't know us, we want to spend just a moment introducing ourselves. I think many of you here do know us, but I am Mark Gilfix, and I've known my co-presenter here, Michael Gilfix, for now over 40 years. Now, why is that? Because he's my father. Michael Gilfix is from a little town in Michigan called East Tawas. It's the Upper Peninsula. He went to Stanford for undergraduate and came out here to California. Very lucky for me. He stayed here and went to the Stanford Law School. And when he graduated Stanford Law School in 1973, he became a social entrepreneur. He didn't just follow the steps of many of his classmates going to big corporate law or big law firms. He truly wanted to share the world, and he didn't know how to do that. He didn't know who to help. He just knew he wanted to help. So like any good entrepreneur, he searched for an underserved community. He searched for a community in need of legal help. And he found that two communities needed help. And that was the elderly and Americans with disabilities. And so he went out and he started America's very first free legal aid program for the elderly, Senior Adults Legal Assistance, SALA. It still exists to this day. He also created the Disability Law Center, one of the first free legal aid programs for Americans with disabilities. He helped shape the field and create the field of elder law. He's been a national leader for over 40 years now. He's written books, articles. He's trained hundreds or thousands of other attorneys. When he started SALA, he didn't just help older Americans here in the Bay Area. He went around the country, helped raise money, helped train others to start similar programs in other areas of the country. So he's directly responsible for helping hundreds and hundreds of older Americans with free legal aid, but he's also indirectly responsible probably for helping tens of thousands of older Americans through all the organizations that he helped to create. He's a great runner. He's had some foot problems recently. He's a top 10 racer in 5K races around the country. One year he finished the top 3 in the beta breakers in his age group. So that's a big deal. There's tens of thousands of people in that. He also has always kind of been there for me and my family. I have to say, throughout the time, he's been a national leader. He started Gilfix in the Pole in 1982. That's when he transitioned to private practice, remained a leader in the field, helped continue to train other attorneys, books, articles, USA Today, Wall Street Journal, The Phil Donahue Show. Throughout all this time, he found time to coach all of my teams, all of my sister's teams, softball, basketball, baseball, you name it. Here's one example of this. In 1990, that's Mike in the top right. That's me in the bottom left, the Outhouse Realty Palo Alto Little League team. So again, we've been here in Palo Alto for a long time, and Mike's been involved. And I don't know how he found time to coach all of our teams while he was doing all this stuff, but somehow he did. So on that note, let me introduce to you Michael Gilfix.
Thank you, Mark. Hey, coaching is fun. That's how you find time. You know, you enjoy it so much. You know, I have to say, I did create Senior Adults Legal Assistance, which still visits Avenidas and provides free legal services in selected areas. And, you know, when I created it in 1973, I did it at the Palo Alto Senior Center. And this is a wonderful historic note. At that time, the Palo Alto Senior Center was a desk in the downtown library, staffed by Diana Steeples, who some of you might remember. And, you know, I stopped in at her desk and said, I'd really like to start this program. And she said, yes. And there we were, you know, no committees, didn't have to go to the city council. We just did it. You know, the good old days when you could just kind of do these things. So there's really a very special relationship that we have with Avenidas, the evolution of the Palo Alto Senior Center. So, you know, it's particularly fitting and appropriate that we're here and doing our best to help out everywhere we can. So with that note, let me move on and introduce Mark. There is a relationship, as you now know. Mark also went to Stanford undergraduate. His degree was like so appropriate for Silicon Valley: management, science, and engineering. Kind of a blend of tech, you know, learning how to program and focusing simultaneously on the business side of the world, side of life. And when he graduated, he joined one of the top international business consulting firms, really in the entire world. He became a consultant to Fortune 500 companies, to the Defense Department, just learned an enormous amount about how systems work, about how government works. That kind of knowledge has been just invaluable in making us even more effective and more successful on behalf of our client community. He also was very successful in the consulting world. He went to law school in Southern California, went to Loyola, a great law school, graduated at the top of his class. He was the class speaker at graduation, which was wonderful. And, you know, real pride thing for the parents, of course. And his focus, by the way, was generosity, which we thought was absolutely wonderful, the focus of his talk. While he was doing that, for enjoyment, and I really think to develop his skills, Mark also became an actor. He enjoyed a considerable amount of success. He was in national commercials. He was on a number of television shows that you've seen. He was the lead in a couple of motion pictures, privately funded. Great success. And one of the most significant things that he did is something where you probably saw him. Believe it or not, you saw him. This is a screenshot of Mark introducing Siri to the world. This is the first time. There's Mark running along the Embarcadero in San Francisco where they filmed it. So this is the first time Siri spoke, that Siri was engaged and revealed to the world. This was on television, it was on the internet, it was all over the world. So millions of people met Mark, didn't know his name, but got to meet Mark. So part of a great introduction to Mark, who also, by the way, has become an award-winning writer and speaker with a number of national organizations. So Mark is out there nationally doing this kind of work as well as locally here for our local client communities. So Mark, back to you.
Yes, well, thank you. Yeah, so I think one thing we want to emphasize, our firm is, long before I was able to act as an attorney, has been around for over 35 years, almost 40 years here in Palo Alto. So we're very proud of our place in the community. We've served thousands of families in the Bay Area, especially in the Palo Alto area. We're proud of our partnership with Avenidas. And we thank the Avenidas team and Tracy in particular for helping us to set this up and to get to share with this wonderful, wonderful community. So again, thank you for being here. So now let's jump into crises. So what are the types of crises that you might face? And it can really be anything. Life is very uncertain. We might want to add to this. So Mike, why don't you go over some of the crises you've helped clients through in the past?
Yeah, I mean, it is unending. We've identified in the slide some of the more obvious things: a stroke, an accident, dementia befalls can happen to anybody at any time. Illnesses, I mean, you just don't know. And it could be a crisis in the family that's with one of your kids or one of the grandkids. We hear this all the time. And dealing with it, if you're not prepared, I mean, just like being prepared for a fire, for evacuations, it's fundamental. We all know this, we all know this, but do we really take it to heart? I have long kind of joked that we often take more time thinking about our grocery lists than we do about our bequest plan and who's going to manage our affairs if we become ill. There are things you can get your hands around a little bit more simply, but we have to be paying attention here. So it is critically important that you speak with your attorney. We hope that's us. If not, talk with your attorney about these issues.
Yeah.
And the core is things happen and you got to be ready, huh? Isn't it obvious?
Yeah. And so what does it mean to be ready? And there are really three core documents. We hammer this in our talks and with clients. There's really three documents that virtually everyone in America needs over the age of 18. One is a revocable living trust. We're going to talk about why that's so important, why it's so much more important than having a will, and some of the decisions you have to make within creating a trust. It's not just as simple as creating a trust. Durable power of attorney for finances. What does that do? Why do we need that? And Advance Health Care Directive. So again, the big three: revocable living trust, also known as a living trust, also known as a revocable trust. There's a lot of terms you'll hear for that. Durable power of attorney for finances, and an Advance Health Care Directive for medical decision making. So if you have these three documents, it's a way of making sure that if you become incapacitated, if you become sick and after you're gone, your affairs are in order and your family's not exposed to court actions or the need to go to court. And by the way, we're going to take questions at the end. We want to make sure we get through everything. So please submit questions in the chat function, and we'll try to get to as many questions as we can at the end of this. And we'll spend a little bit of time at the end doing that. So apologize, we can't take questions during this because we have a lot to get through.
So let's do kind of an overview of the revocable living trust. Now, most of you probably have that in place. We're a very sophisticated community. So by the time we get to be a little older, you've heard about trust time and again, you probably have one. If not, you should. You know that you should. Okay, so when you do a trust, it's not like a trust is the same thing for everybody. It's not vanilla. One of the most popular webinars we've ever done was one where we basically said, you are not vanilla. Every family has issues. Everybody does. So drafting a trust is not grabbing a form and plugging you into the form. It's making sure that it speaks to you, that it addresses issues in your family. So it's got to be right for you. I mean, it's an obvious statement, and yet, I know it's overlooked routinely. If you have if you go to one of these, for lack of a better term, a mill where trusts are done at a very low fee is fine, but you're going to be made into vanilla, and they're not going to take the time to get to know you and your circumstances. There are tax issues galore that have to be addressed in your trust planning. Estate taxes, gift taxes, capital gains taxes, income taxes, property taxes. All these issues come up when you have a trust and you transfer and retitle assets in your trust. Who's going to be in control? I mean, obviously, you're going to be in control when you set up your trust, but we're going to talk about the role and the need for a successor trustee and having the right person. So, and I've made the point, not off the shelf. You know, you can find a trust form. You can find a form for anything these days. You know that's crazy. I mean, you know it is. So you don't do that. You talk with somebody who knows what they're doing, and you make sure that the trust is appropriate for you. Okay. You did your trust 15 years ago. Whoa, what a deal you got. You paid $800, and it's great. Here we go again. You know, not so. Number one, it's not a deal to have something simple done for you because you're not simple. And if it was done 15 years ago, the law has changed. You have changed. Family circumstances have changed. The cost of long-term care has changed. Everything has changed. So you need to revisit these things. So the bottom line with the trust is going to govern so many of your financial and related affairs. It's going to determine how the extent to which your assets are protected for the benefit of your family and how they ultimately inherit. And that's not a simple question either. We're to talk about how inheritance should be set up in a very protective way. Again, not vanilla. Revocable trust is the core document, part of the big three as we move forward.
You know, why a trust? You know, I have a lot of clients who ask, well, you know, I have a will, or friends will ask, I have a will, why would I need a trust? What's the difference? A will is, I see that in movies, people, they have the reading of the will, what's the big deal? Number of reasons why a will is not good enough. So if you just create a will and you say, you know, everything to my kids or whatever you do, big issues. So if you own any property or if you have over about $150,000 in total assets, you are exposed to probate, or your estate is exposed to probate, meaning everything has to go through the California court system. A judge has to sign off on everything. And if you love going to the DMV, if you love dealing with the IRS, you will love saddling your family with probate. Probates can take 2, 3, even 4 years. We've had some nightmarish ones that were started like a decade ago that still aren't closed. That's the exception. But certainly at least well over a year. The fees are extraordinarily high. They're set by the court. There is no wiggle room. The court fees, the attorney fees, the fee for the person representing your estate, they can be massive. Public. So whenever you see like a celebrity who passes away and then you see weird stories about everything in their estate, you're thinking, why do I get to know everything about this? James Gandolfini is an example we use sometimes. The star of The Sopranos, when he passed away, there were a bunch of stories in the tabloids about everything he had and where it was going. Now, why? Because he had a will that was exposed to probate. So everything was public. It's, again, time-consuming. Court timetables, delays, you're subject to the whims of the court, especially with the pandemic. It's very hard to schedule things right now, and it's only effective at death. So you name an executor in your will, but that person cannot help you while you're alive. They have no role to play. They only have a role to play after you're gone. So it doesn't help you while you're alive. It exposes your estate to probate and all kinds of issues associated with that. By the way, if you have any property in other states, like a cabin in Michigan, like my dad's always talked about getting, if you had just a will, you'd have a probate in California and a probate in Michigan. So all kinds of issues with that. They also tend to be a lot simpler. You can't really build that much into wills. It's just not that efficient. So a trust. Trust is the answer. Again, living trust, revocable living trust, whatever you want to call it. What are the benefits? Well, one, you are privatizing your estate. So after you pass away, if you have a trust and if you've properly titled your assets in the trust, which is very straightforward, you avoid probate. Assets go to your family members without being exposed to this public process. The fees are much lower. 50% lower, if not even less, compared to a probate. The time frame is much faster. Typically, it can be done in under a year. While you're alive, very critically, you name a backup trustee who can help you. So if you become incapacitated, you own properties, your backup trustee, the person you've named, kind of the executor role, can pretty seamlessly step in to manage your major assets without too many hiccups. Again, a will doesn't help you in that way at all. So having a will, sometimes it seems simpler and it seems like you'll save a little money up front, but down the road, it will cost you and your family tens of thousands of dollars, if not more. Francis LaPaul, my dad's partner, who's been a part of our firm for over 35 years, I think one reason he went into this field was that he told the story of, he used to know some attorneys who would do free wills for people. Why? Because they knew that down the road, these people would be exposed to probate and they'd be making a lot more money dealing with the probates than they would have if they created a trust. So, bottom line is for 98% of the people that we work with, a trust makes a lot of sense. Within that, again, there's a lot of decisions to make, but we always walk people through that. It's determining where you want your assets to go, who you want to step in to manage your affairs when you need it. So now let's talk about a durable power of attorney and how that fits in. So Mike, why don't you talk about how that fits in with the trust?
Yeah, so we have two other core documents, right? We have the durable power of attorney, and the next thing I'll chat about for a moment is the Advance Health Care Directive. So with the durable power of attorney, you're signing a document where you empower a trusted individual, somebody deeply trusted, who can then sign your name, can take care of things for you if you can. Now, to the extent that you have a trust and assets in the trust, the successor trustee is the one who would manage it. But many activities are outside of the trust. The most obvious example would be retirement assets. They're not titled into trust. There's no probate because you designated beneficiary, but if a document needs some signature regarding your IRA and you're incapacitated, it's the durable power of attorney, if it has the proper language, that would enable that individual to do so. So again, you name a trusted individual, you have a backup. There are some durable powers of attorney called the statutory form that are like 2 pages. And in most situations, that will be fine, but not in every situation. So here we go. Again, it needs to be a sophisticated document. The fee is modest. The impact, if needed, is absolutely massive. One of the points that we emphasize, 2 points in closing about this. One is, if you name the wrong person, they have power. And we have seen durable powers of attorney abused. So again, don't name your new best friend in your durable power of attorney. Name somebody you know and deeply trust, or you just can't do it, okay? Second point is, a sophisticated document doesn't just say, I empower someone. It's very detailed and very specific. It can empower someone to do protective tax planning for you. If you're incapacitated and you have a taxable estate, it can enable somebody to take asset protection planning steps for you. If, God forbid, you need to be in a nursing home and you need to look at Medi-Cal, a government program that can pay nursing home bills, sometimes that's appropriate. But what if you're ill and can't do the planning yourself? It's through a power of attorney. If and only if it has the appropriate language, it's through that document that somebody would be able to do that for you. So again, another critical document. It has to be updated. It has to be fresh. 30-year-old document just doesn't do it. Logical objections to whether it's still in place. Next document is the Advance Health Care Directive.
Yeah, I actually want to add just 2 notes there. So just about the point of an old document, one term that comes up a lot is a document becomes stale. If it's old, power of attorney documents are presented to banks and financial institutions. They're not exactly organizations that are out to really make things easy for you, as I'm sure you guys all know. If the document is old, they often either won't accept it, even if it's valid, or they'll cause all sorts of issues. The more recent the document is, the less likely you'll have that issue. And just another point, just about Mike said about the tax and long-term care planning provisions, often that small section of the document, we make sure we go over this with our clients, is the most critical part of your power of attorney going forward. Those provisions can be worth hundreds of thousands of dollars to your family in certain situations. So just the power of attorney is not a throwaway document. It's so, so critical. So sorry, didn't mean to interrupt. Back to Advance Health Care Directives.
Sure. Of course you meant to interrupt.
I did mean to interrupt.
That's what we do in these talks. We interrupt, we flow.
Yes.
Needless to say, we don't have a script. Needless to say.
I think that's pretty clear.
That's very clear. Okay. Advanced Health Care Directive. So here, you're doing 2 things. First, you're naming, again, a trusted individual who has authority to make healthcare decisions for you if you can. Secondly, you're describing how you want critical decisions made, and you can be as detailed about that as you like. What about end-of-life decisions? What do you want done? God forbid, you're in a coma, dementia, all these issues that are so hard to deal with. And that underscores the fact that simple forms, as always, simple forms are simple. They don't address some of the more challenging circumstances that come up. You may have issues of great concern to you. They may be religious. My advance directive is very clear in saying that if I'm ever ill and in the hospital, no rap music shall be played in my room.
Noted.
So you can specify classical music. You can specify whatever you like. You can talk about whether organ donations are okay with you. You can talk about burial. You can talk about worries that you have. So again, when we do these documents, they tend to be long. They tend to be detailed. Fees are really minimal, but they should be sophisticated and reflect your wishes. And there needs to be a discussion, a thoughtful discussion about these issues.
Yeah.
We'll close on the last point, the point that we continually reiterate and reemphasize, especially with an advance directive. If it's old, 10, 15, 20 years old, a doctor will logically, many doctors will logically say, look, this thing was signed 20 years ago. How do I know it still reflects her wishes? So for the sake of effectiveness and efficiency, you need to update that document and make sure that it's current and that you're refreshing it, for lack of a better term. So again, not off the shelf, not too simple, deal with it proactively and be detailed as you can be and still be comfortable with the contents.
Yeah, a couple just small additions I want to make is we had a lot of clients come to us with just concerns about COVID and what might happen if they're in the hospital. And there was a lot of talk about ventilators and what the best type of treatment was. And I know that's evolved a lot. So we've had some clients come in and say, hey, you know, I want to add something that says if I have to go to the hospital, I don't want to be put on a ventilator if I have COVID, or there's specific things you can put. You can also add a letter of guidance. So that's something that directs your loved ones to add some additional details about what you'd want. So you have this formal document presented to doctors, but you can also talk to your family about what you'd want, and you can put it in writing as just a letter that you keep with your documents about the other guidance about what you'd want if you're in the hospital, can't make decisions for yourselves. And that kind of relates to the next subject, which is involving the next generation. And that's something we obviously talk a lot about because I am the next generation here. What should you do to involve your kids, or maybe if you don't have kids, your loved ones who you've named, or your friends or your close relatives, whoever that is who you want to involve? Ideally, you would share copies of your documents. Now, maybe you don't want to share everything about where you're leaving assets if your kids are involved, especially if they're younger. So maybe you don't share your trust necessarily, but it is important to let them know what's going on. You got to accept reality. You're going to need them at some point. So there's a few different ways you can share. Obviously, it depends on family dynamics. Some families, it's great to share everything. Other families, it's a minefield, and you got to be super, super careful about what you share and what you don't. The more conflict, the less you can share. But what we found is the more that families communicate ahead of time, the less conflict there often is. We have a lot of clients who are concerned about, well, both my son and daughter are great. I don't want to name one ahead of the other. Well, talk to them about it. Let them know, hey, I'm just going to name my son over you, my daughter, because you're older and you live nearby. It's not personal. But talk to them about what these rules are, what they might have to do. Let them know that they have resources. They can talk to an attorney. They can talk to your financial advisor. They don't have to just do everything themselves. But the more you can include them, the better. And with a lot of our clients, after they create their documents, we'll set follow-up meetings where they will bring their adult children or even not so adult children into a meeting just so they understand what their plan is, and to give them a face for their attorney to let them know that we're not some big, bad, evil corporate attorneys who are terrifying. Nothing against corporate attorneys, but some types of attorneys are really scary. We're on the nicer side of this 99% of the time. We get to be the good guys helping families out, but it's often important for families just to know that we're there as a resource, whether it's us or another attorney. It's really good to bring your kids into that process if you can, or again, if you're not naming your kids, or if you don't have kids, your closest relatives or your close friends who you are naming in these roles. So really important. So another question, shifting gears a little bit. We get this all the time. What do I do to protect assets for my kids and my grandkids? I had a call this morning where my clients were not so thrilled about their daughter's boyfriend. They said, hey, he's a nice guy, but we don't feel that good about him. How can we protect what we're leaving her from him, or from divorce, or from whatever that is? There's a very powerful tool available to do that. And it's called a family protection trust, generically known as a dynasty trust. And we pose the question, why does Bernie Sanders want to get rid of these? There's pretty good reasons. Why would you create a family protection trust? You'll see why Bernie Sanders and some politicians might not like them as we go through this. So here, imagine you create your living trust. Let's say you have son John and daughter Mary. So instead of leaving money to John and Mary directly, you create a family protection trust for John and a family protection trust for Mary. You would not leave money to your son John and your daughter Mary. You leave them to their family protection trust. So they would never actually inherit any of your assets directly. Now, why would you do this? Well, if you leave it to a family protection trust, if your child endures a divorce in the future, The assets you left them are in this trust. They're not commingled. They will not get lost in a divorce settlement. If your child is sued, car accident, business deal, maybe they're a doctor and they're just in a very high risk profession. Assets in the trust have a high level of protection against creditors and litigants. It's not guaranteed. We can't make any guarantees, but it's a barrier. Someone has to break through that trust to get to that money. If you leave money directly to your child, fair game, no barrier. Very, very powerfully for those of you who have grandchildren or think you might have grandchildren in the future, the assets you leave into these trusts, plus almost all of their future growth. There are some limitations, but a massive amount of growth during your child's lifetime. So let's say you leave, $2 million, value of a very small house in the Bay Area in one of these trusts over 10, 20, 30, 40 years of your child's life, that can double, triple, quadruple in value. That could be a lot of money by the time your child passes away. We have no idea what estate tax laws will be when your child passes away. They might be very strict. If it's part of your child's estate directly, it all could be exposed to estate taxes. 40, 50% of it could be lost to the IRS. Here, a good portion or maybe all of the money in this trust and future growth continues in the trust for your grandchildren with zero estate tax exposure. This can save millions of dollars, even if you don't consider yourself high net worth. That's a big deal here. One thing that I'm kind of passionate about is high net worth, wealthy families have been doing versions of these trusts for years. There is no reason why this should be a tool only reserved for billionaires and ultra high net worth people. Really, any family can benefit from this, especially if you own a house in this area. That alone justifies this. A lot of people also think, well, if I do this, then am I tying my child's hands? I don't want to do that. I don't want to control from the grave. Well, if you allow it, you can make your child his or her own trustee. So, John and Mary, those examples before, John can be the trustee of John's Family Protection Trust. So he's in charge of it, he gets the benefit of it, but still it's in a trust. And you don't have to name your child as trustee. You can name a co-trustee. If they're younger, you can say, well, when they reach the age of 35 or 40, they become all kinds of flexibility, but you're not necessarily tying your children's hands. So it's just an extraordinary tool. It's almost like magic from a legal standpoint. Minimal downside. There's some additional logistics they have to deal with, but all these incredible protections against divorce, lawsuits, and future estate taxes. So now let's talk about different situations. So Mike, why don't you talk about if you have a child with a disability or with special needs?
Sure. So if you have a child or grandchild who's able, capable, we focus on the Dynasty Trust, on the Family Protection Trust. It's, we hesitate to use the term no-brainer, but the protections are so massive that, we presumptively do them for everybody, for the kids. Okay. Now we have a situation where a child may have some form of disability. It could be schizophrenia, substance abuse, alcoholism. The list is massive. So what do you do for that child? Not able to work because of the disability. So that means that your son, let's hypothetically say, is not able to make a living. He's going to qualify for a number of government programs that will provide him with an income. It's a program called Supplemental Security Income. He'll qualify for Medi-Cal, which will give him a health insurance program. Subsidized housing may be available, but if he inherits money directly, it becomes his and he'll lose eligibility for those programs. So the solution, not an option in this circumstance, the solution is something called a special needs trust. A special needs trust can hold any amount of money, doesn't matter how much, and it's there as kind of a lifelong safety net for your child to pay for anything he needs that is not adequately covered by government programs for which he qualifies. None of it counts. So if he was getting SSI, this income program, and if he was getting Medi-Cal, he's going to continue to get them, even if you leave $1 million, $2 million in that trust. And I'll tell you, we're so worried about the solvency and the effectiveness of government programs. There has to be a safety net there. There just has to be. Housing alone is a concern that drives most parents crazy if they have a child with a disability. So you need to think this through. It's a complicated topic. We could spend 30, 40 minutes on it. We're going to leave that with you because again, our focus is on the basic documents. Now, there's something else relatively new called the ABLE Act. It's another example of opportunities to set money aside for a child who is qualifying for government benefits and yet not interfere with eligibility. So these are it's a relatively new law. Money can be put into an account called a CalAble account. You can put up to $15,000 a year into that account. Your child can even manage the account and none of it counts, doesn't disturb eligibility for government benefits, and the money can be used very liberally. So again, it's an aspect of special needs planning, only one of many, many, many. We're not talking about everything, but again, from a trust perspective, our focus is on the special needs trust. We want you to be aware of other issues like the ABLE Act, but again, you leave money not to that child with a disability, you leave it to the special needs trust that you have created for that child.
Mm-hmm. Yeah, and we're about to publish, it's been a long process, we're about to publish a new book on this, by the way. So special needs trust is absolutely critical, a way to provide a lifelong safety net for your child. Special needs trust creation management guide, version 2, volume 2, updated, is about to come out. Mike and I co-authored this version. We expanded on our previous version, so that's available if you want to get a copy, and we always have that available. We give it to our clients who work with us in the special needs place. So we spend a lot of time thinking about this, and it's an area that we're very passionate about because it's so extraordinary what you can do to protect a loved one long term.
So one of the most important decisions you have to make, and we've alluded to this already, is who's going to be your trustee if you're ill, or who's going to be the trustee of that special needs trust. Who's the dependable, trusted person? So the point to emphasize above all is that you have to choose somebody who is responsible. Responsible. It's not who do you love the most. Coincidentally, that may be the responsible person, but it's not who lives nearby. It's who's going to do the job. And that doesn't mean, by the way, that your successor trustee needs to understand investments from upside down in just every aspect, but they need to know what they don't know, and they need to know how to go get professional advice when it's needed. That's responsibility. It's taking care of things. It doesn't mean you have to know everything. One of the main things is it means you need to know when and where to get help. Okay. If you don't have a child or a close family member who can do this for you, and many don't, even if you have a kid, you might not have a kid who can do it. Then you have to look to other opportunities, other options. One is a professional. There are people who are professional fiduciaries. They're in the business of being trustees. Many attorneys do it when appropriate. We do it selectively. We don't make this a main thing we do. It's only in those, frankly, rare circumstances where there's not another option. Banks are always available. Very few are comfortable with that, but that could be appropriate in many circumstances. For the trust and for the durable power of attorney, we're focusing on those documents on the business of life, money, management, things like that. So the individual you choose to be the responsible individual in those contexts, that may be different than the person who would be named in your Advance Health Care Directive. So, just to say, it's not the same set of issues. For the Advance Health Care Directive, you might name somebody different. Who's going to be an able healthcare advocate? Who's comfortable in a healthcare setting? So again, this is a tough issue. It's often the subject of a 10, 20, 30-minute discussion to come up with the best possible solution. It's not a no-brainer. It's tough. We acknowledge that.
And now let's talk about how do you put these into place just logistically. We've talked about all these documents, but how can you actually do these? So one, if you don't have these documents, you got to put them into place. How do you do it? Or two, if you have them, but it's been a while, or if your situation has changed, even if you created them fairly recently, what do you do? How do you update them? Well, if you've been through this process before, you're probably pretty familiar with it, but you really need to meet with an attorney. And these days, of course, that can be done remotely. I would say that the vast majority of our meetings are via Zoom, some in phone. Rarely we've done in-person appointments. Sometimes we do them outside. We have a big conference room. We all wear masks. We have an air purifier in the room. Obviously, you got to be safe. Most of our clients have been comfortable with Zoom meetings. So you can do this from your living room now or your bedroom, anywhere. And you need to make these decisions with expert guidance. We just see one bad decision can undo every good piece of your plan. If there's your plan is only as strong as its weakest link. So it's critical you do it with expert guidance. Again, as Mike said, it's not just creating a trust. It's talking about the trade-offs of different trust structures. There can be massive tax implications. There can be massive control implications. If you're married, if you get divorced, if you have kids from a previous marriage, all kinds of complications can come up. So it's really critical that you work with an expert on doing this. And then if you're creating the new ones, when we work with clients, we have the remote meeting in many cases. We'll send drafts as PDFs or hard copies. You review them. If you approve them, you notarize them. And once they are notarized and signed, they're in place and they're effective. They're not effective until they are signed and notarized. And then after that, ideally, as we kind of talked about, you should talk to your family about them. If it's been a long time, even if you already have a plan, maybe this is an excuse for you to talk to your family about it now. Even if you don't need to make updates, use this as an excuse. Say, hey, I just saw a webinar. We should talk about our documents. We just want you to be aware of what we have and how it kind of works. Because for a lot of people who aren't exposed to this, and you guys are ahead of the game now, it's just a very foreign world and it sounds scary. You know, until I practiced in this area, the term trust just had this weird power. You know, I didn't, coming over even in a family of estate planning attorneys, both my parents are, I still didn't really know what a trust was. And the term power of attorney, is that like some weird lame superhero? Like, it makes no sense. I have power of attorney, but they all are really meaningful and powerful. And when you break it down in plain English, it does make a lot of sense. So once you create them, we strongly encourage you talk about it with your loved ones and maybe share them or share parts of your documents with your loved ones, because they're going to be called on at some point. And how do you use these in an emergency? So let's say you do get sick, you know, God forbid you get COVID, or you're in an accident, or just something comes up that you couldn't predict, a stroke, whatever it is, or maybe you just are overwhelmed and can't deal with your own affairs anymore. That happens. If you're incapacitated, well, these documents come into place when you get doctor's certification that you're incapacitated, which can be as simple as a note signed by a doctor declaring that you're incapacitated. You don't have to go to court for that. It can be done just by a doctor. If you know that you're in a bad place and need help, you can voluntarily resign as your own trustee and give someone else the power to step in for you pretty seamlessly. For your trust to really work, your assets have to be in the trust. So another reason why it's so important to work with an expert is your home, for example, or if you have a rental property, whatever, they have to be titled in your trust via the deed for the property. It can't just be, I put it in my trust. No, it has to be a recorded deed with the county. It doesn't change your property taxes, but your real property, your financial assets, you know, so your investments, your retirement accounts are not in your trust, but all your other non-retirement accounts should be in your living trust. Very straightforward to put it in, but if you don't do it, it can cause problems. You should have extra copies of your advance directive. Give it to your healthcare providers. Give it to your doctor. Make sure they have a copy on file. Power of attorney. The person you've named as backup should have a copy of your power of attorney. You might give a copy of that to your bank or to your financial advisor so they know ahead of time, hey, if something happens to me, this person is in line. They might also want a copy of your trust, or we create something called a certification of trust, a quick summary of your trust. It's all that financial institutions really need to see to know that you have a trust, to know who can step in. So you want to have copies of these documents. You give a copy of the certification of trust, the power of attorney to your financial advisors, a copy of the advance directive to your medical providers, or at least let your loved ones know where they are. So in an emergency, they know how to get them. You can email them to them. PDFs. For our clients, we're available as a resource. So if something happens to one of our clients, we of course have scanned copies of everything. You can send them to anyone that they give us permission to send it to. So, you know, they don't just spring into place magically, but it's not that hard. And if you need them, they're there for you. But we definitely recommend that you get copies of the people named in them and that you just know how the process works so they can do their job if and when you need them. So again, you know, what could be your personal or family crisis? What could be this crisis that puts these documents into place? Well, a stroke, dementia, expensive long-term care. A lot of clients who we hope you never need it, but you have to go to a nursing home, and that's going to be a subject of one of our other webinars, by the way. So look for that. We're going to talk exclusively about long-term care and asset protection. What could be the thing that requires that? What if you have to go to a nursing home? The cost can be $15,000 a month. That could be a time where your documents are needed to protect your assets if you can't make decisions anymore. What if one of your kids gets a divorce or gets sued? How can you make sure that money that you've put into place for them is protected? Or COVID, you know, coronavirus. Hopefully there won't be a big winter surge, but who knows? You know, we all got to be careful, and we never know we're going to need these. So have them in place, talk to your loved ones about it, make sure they're up to date. So why don't we revisit the mystery that we talked about at the beginning?
Right, so you remember Larry and Wyatt. Larry is the guy who had the problem, and while he was incapacitated, everything was a mess. And Wyatt, not so. Same rough profile, but everything was taken care of for him. So you can guess the reason. You can guess the answer to the mystery, okay? So the dramatic difference is that one plan, Wyatt planned. He did the basic documents that we talked about. He was incapacitated. The individual who was given authority and responsibility knew it. He did communicate with that child of his, and she was able to step up and take care of everything for him. She had the power to be the trustee and manage assets in the trust. She was named in the durable power of attorney, so she could deal with other issues. She was named in the Advance Directive, and she could make sure that medical care decisions were properly made. So these are very real profiles that we see all the time, both the situation where somebody doesn't plan and the obvious benefits and the money saved and the aggravation and the worry saved if you plan properly. So Wyatt wins, Larry and his family lose big time.
Yep. And by the way, for questions, I saw a couple of people have been raising hands. Please enter your questions. You can do it either in the Q&A or the chat function. We'll try to get to those at the end. We don't have too much more to cover, but we want to make sure we get through the last couple steps. One subject that I think is critical for us all to be aware of is the estate tax. Right now, it doesn't affect many people. It's a very punishing rate. So any dollar over the exemption amount, if your estate exceeds the exemption, the amount that can go tax-free, 40% of every dollar, 40 cents of every dollar goes to the IRS beyond the limit. Right now, though, it doesn't affect many people. If you have an estate that is taxable, great, it's good. It means you have a very large estate. Why? Because you can leave up to $11.58 million to your heirs per person without a penny of estate tax exposure. So between a couple, for a couple, if everything's done properly, that's $23 million under current law that can go free of estate tax. Very importantly, we get this question all the time, is the receipt of an inheritance taxable? No, it is not. It doesn't count as income. So if you leave money to a loved one, to a child, they do not have to pay taxes on the receipt of an inheritance. California does not have a state estate tax. Some states do. Yet, who knows? There have been bills introduced in the assembly in the past. 2 years ago, there was a bill that went to a committee about creating a state estate tax, but that didn't go anywhere. But who knows? The state, just like the federal government, is running a massive deficit. We've got to keep an eye on this. So right now you might be thinking, well, I don't have $23 million, I'm good. And if you do, you definitely need to be aware of this. But you might think, I'm not close to that. But we got to keep a close eye on this. So first of all, most of us have estates that are larger than we think. It includes your retirement accounts. It includes life insurance payouts. It includes property here and in any other state and in any other country. So your estate is probably significantly larger than you think. I think our experience is most of the time when people come up with a number off the top of their head and we actually add things up, their estate is usually about 20% or more bigger than what their rough estimate is when they actually add numbers up. But you still might think, well, I'm not close to 11.58 million or 23 million. 2026 is a key year. For those of you who watched Game of Thrones, winter is coming from an estate tax standpoint, and maybe sooner. So in 2026, if nothing happens, if Congress doesn't touch this, the current law will sunset and the exemption amount will go from 11.58 million per person. It'll be cut in half. So it'll probably be around 6 million. It's indexed with inflation. So at that point, think 5 years from now, we're really coming up on just 5 years, January 1st, 2026. If you own a house in this area, if the value just goes up, 5% a year, that's another 5 years of compounded growth. So the value of your home could get you closer to this than you might think. But you still might think, well, maybe I won't be close to 6 million. Well, it could change before then. This is just if Congress doesn't do anything. Depending on the elections this fall, there could be big changes next year. So we got to keep a very close eye on this. And for those of you with larger estates, you got to be aware of this. There's a lot of steps you might take now to protect some of your assets, to get them to the next generation, to avoid unnecessary tax exposure. You don't have to, but there are a lot of techniques that can be used where even if you do have a larger estate, very good place to be, where you don't have to get hit as hard as you might think. So Mike, why don't you talk about some of the steps you might take to reduce estate tax exposure?
Sure. So needless to say, this is a topic that could take an hour or 2 hours. No effort is made here to be exhaustive or get into any details. And the second introductory comment is that if you have this problem, hallelujah, hug that problem.
Yeah.
It means you have a large estate and maybe there'll be some tax. Not the worst thing in the world, right? Better you should have the problem if you do than not. So, perspective is real important here. Okay, so many things can be done. If you're a married couple, you may have what is called an AB trust that may or may not be necessary or appropriate for you. It does have an impact. It has a significant impact on estate tax protections that are to be captured. So the nature and structure of your trust matters. If you did your trust many years ago and you have the AB trust, you should talk with us about an alternative approach that can still give certain tax advantages and may be more advantageous for you. There are some simple things that you can do to reduce your tax. There's something called the annual exclusion. You can give away up to $15,000 to as many people as you like, year after year. If you have a minor child or a grandchild, we can set up a trust that will let you do that. Believe it or not, it's called a crummy trust. Amazing term, huh? So that can be done. You can pay medical bills for people, and that doesn't erode your tax protections. You can pay tuition for anybody. So again, there's a number of fundamental, relatively straightforward things that you can do that don't take sophistication. If you have a larger estate, the list of more sophisticated steps you can take, I wouldn't say it's endless, but it's huge. We have another book that I've authored called Beat Estate Tax Forever, and I just finished the 3rd edition that has all the current updates. There's an extensive list of more sophisticated planning options that exist. So let's assume that this year somebody has remember, for a married couple, the level of protection approaches 24 million. So if a couple has 30 million, believe it or not, if we do planning right now, I'm highly confident. I believe that we can put together a planning approach that will eliminate the estate tax, even though it would seem that everything over 23 would be exposed to the 40% tax. There are tools available. Discounting is used in so many contexts. There are sophisticated trusts galore, most irrevocable. You see the reference in the slide here to GRITs, that stands for Grantor Retained Interest Trusts. GRAT is a Grantor Retained Annuity Trust. The acronyms can drive you crazy. Bottom line, there are many things that you can do. If you're uncomfortable with the 40% tax, with that level of exposure, again, if you're a single person, you're over 4 million, you need to think about 2026. A couple, if you're at 7 or 8 million, you need to think about it come 2026. So it's an expansive topic. We're sophisticated. We can deal with it. So many options exist. So again, we want you to be aware of the book that we're updating right now to know that we can take care of these issues. And we make the point on this slide that it can be very powerful to coordinate your estate planning with your investment strategies. They can reinforce each other. And we're developing a lot of relationships with folks with whom we think we have a great relationship. We're on the same page, and we can kind of reinforce the planning for your benefit.
Absolutely, yeah. Coordinating financial advisory services with legal planning can be so powerful. And as Mike said, we're working on developing some programs in partnerships with some financial advisors around this. So as we wrap up, because I know we're getting to the end of our hour here, what can you do now to protect your family? So I think the first thing is overcome the danger of denial, and I would add delay. Overcome the danger of delay as well. My kids won't ever divorce. That's not going to happen. I'm not ever going to need long-term care. I'm going to live forever. Or I already did documents 10, 15 years ago. They're fine. Or I can wait. This can happen another day. I'm busy. Don't let that happen. If you don't have a plan, or if your plan is not up to date, it can cause so many issues. It's not that difficult to update things. Of course, we invite you to work with us if you'd like. We can review your existing documents. Of course, we would love to get the chance to work with you. And we want to offer everybody here a 15, or we'll actually extend it to 20-minute complimentary call or Zoom meeting with us. I'll give some contact information in just a moment. We're happy to do that on a complimentary basis for people we haven't already worked with. So for new clients or new people who we don't know us, who just like to spend a little time with me or Mike or another member of our team, let us know, and we're happy to set a 15 or 20-minute chat with you at no charge. And if you have worked with us in the past, we're always available to help you. Regardless, this hopefully is a gift, and it's a gift of getting your attention and getting you thinking about this. So use this momentum. Of course, we would love to get the chance to work with you, but regardless, if you have another attorney, if you have another resource, use this as a chance to review your documents, to talk to your family, to bring these subjects up, and to take some control. There is so much that we cannot control in life. This is one of the areas where we can take some control. And I don't know about you guys, but I feel pretty overwhelmed right now with what's going on in the political arena, in the health arena and the fires going on, it can be just too much. We can help you boil this down, and at least in these critical areas, we can help you to develop a really powerful plan. And regardless, I hope you take some action here. There's a link to our Calendly. So that's another way to schedule without contact. You can just click a time and enter your information. We'll put it on our calendars. You can call our office, 650-493-8070, or contact Ashley at our office to set things up. I'm going to try to put this link in the chat box, so you can just copy that link if you want to set a time with me. So on that note, thank you guys so much. We're going to take a couple minutes to answer some questions. We know we got some good questions here.
I have one. So I see one here. I'll start responding to some questions.
Okay.
So the first is you're a married couple and you did your trust about 6 years ago. You think that your attorney is retiring. Should you go back to that person or us? Well, that's up to you, obviously. If an individual is retiring and he or she was a sole practitioner, frankly, that's not a good sign. I mean, we have obviously a succession plan. If I do retire, which I have no plans to do, Mark is here, we have 2 other younger attorneys, so we have a succession plan. So that goes to the issue of who's going to be available to you and your kids over time. And if you did your trust more than 6 years ago and you're a couple, you probably did this thing called the AB trust. I've alluded to that. Maybe that's appropriate. There's an alternative approach that should be talked about. So it should be examined. You should look at the pros and cons of the AB trust and whether you should change it to an alternative, arguably simpler approach.
Mm-hmm. Now, some other good questions here. By the way, thank you guys for letting us know that you could hear us at the beginning. I know I was having some issues. He was having some issues. Thank you for bearing with us. So one question is, a low-income family going to need a trust, or do they need a legal advisor in setting it up? And how often do you need to update these documents to avoid being stale? So it's a 2-part question. So low income is a relative term. If you don't own any property and if you really have very few assets, potentially you might not need a trust. Maybe a will would be enough, because if you have a very smaller estate, you wouldn't be exposed to probate. If you're under about $150,000 in total assets, you can avoid probate even with just a will. You absolutely still need a power of attorney and an advance directive. How often do you need to update those so they avoid being stale? Our general recommendation is you should take a fresh look at least every 5 years, 3 to 5 years. Certainly if anything changes in your life, if the person named is no longer in your life as your backup agent, you got to update that right away. You don't want someone who's out of the country, ideally, that you can name someone out of the country, but you don't want someone who was close to you when you created the documents who's no longer in touch with you. So, stale, certainly anything over 10 years old, absolutely is stale. You'd want to definitely do a new version. Really, every 5 years, realistically, is a good time to update your power of attorney, your advance directive.
Yeah, I'll just add, a lady I met with yesterday, she had us do her trust about 30 years ago, and she came in for a review. And we said, we concluded at the end of the meeting, every 30 years, we should get together. So we're doing that. 30 years, we've calendared the next meeting.
It's time. Yeah. So a couple other questions. One other good one. So can I act as so let's say my mom names me as her attorney, in fact, names me in her power of attorney document. Can my mom still make her own decisions and manage her finances? So yes, you can name someone. So a lot of our clients will say, I trust my wife or my husband or my kid. I'm going to give them power of attorney right now. They don't have to show that I'm incapacitated. That's an option you have. You can say it's only if I'm incapacitated can this person act, or you can say they can act on my behalf right now. If you give them that power right now, it doesn't mean you can't sign for yourself. It just means that they don't need to show a doctor's note to your financial institutions. They could go in the day after you sign to do something, they could undo it in theory. So it'd be joint powers. They can act with you. You can always revoke it, by the way. So it's not like, if you give someone that power, you no longer can make decisions. Absolutely you can revoke it, you can do whatever you want.
I have another one here. So this one is about the Family Protection Trust. And the question basically says, how can that be? How can it avoid estate tax exposure that much? So remember, that is a good question, because it's odd. Okay, so again, remember the concept is, upon your passing, let's say you leave $5 million in this trust for your child. The important point is the trust is structured so the $5 million never becomes part of your child's taxable estate. there's something called generation skipping, which is what this is all about. So it's not in your child's estate. The money grows, let's say it goes to 10, 15 million. When your child dies, it passes intact to your grandkids, who are the perfect people in your lives, right? So, and then again, your grandkids inherit this money in the same trust structure. They get to grow it again. I mean, it is phenomenal. And it is why wealth does get concentrated in families. You know, Bernie's got a point. If you strongly believe that wealth should not be grown and protected from generation to generation, then you wouldn't be in favor of this. Most of us are. You know, most of us want to protect our families. So, yeah, they're amazing. Yeah, they work.
Yeah, and it's our job to inform you. You know, some people don't like the idea of it, and that's fine. You know, we're here to let you know what's available. That's our job. We don't make judgments on what's right or wrong within the law. If it's within the rules, we want you to be aware of all the tools that are available. So on that note, we had some other questions that I think are very specific to some special needs planning issues. That's not the subject of this talk, but we're happy to chat, you know, later about that. But on that note, thank you so much. We have other webinars coming up with Avenidas. Check with them. We have 2 more coming up. We're gonna have one that certainly focuses on long-term care planning and what you can do to protect your house and your other assets. Such a critical area. So look for those. We welcome you to those. Share it with your friends. We record our webinars and make them available on our website. So if you want to share this, feel free to do so. And if you'd like to meet with us, let us know. I did paste the link to set that up just directly online with me. You can contact our office. Again, that's call our number 650-493-8070. Gilfix.com, not hard to find us. But anyway, thank you so much for spending time with us. I hope you got something out of it. And I hope you guys are all staying safe and healthy. And I hope the air stays clean. And I hope everyone's doing okay. So on that note, thank you so much. And we'll hope to see you soon.
Be well. And thanks to Tracy again.
Yes. Thank you, Tracy.